Welcome to today. Good morning, students. Welcome to today's session. As always, please can we mute ourselves and only unmute if you have a question to ask or if you have something to say. In today's session, we are going to talk about the interest of the children of divorcing parents. We know that in most marriages, spouses usually have children. The children whom we'll be speaking about today can be the children who were born before the parties got married, or the children who were born after the parties, after the spouses got married. What you must know is children of the spouses who were who they had the children before they got married are going to be regarded as children who were born in a marriage, as long as the spouses are both the father and the mother of those children. If the child is a step child, the only time the stepchild will receive certain rights is if, firstly, let's say the step parent has legally adopted the child, or they're going to get the rights either if they have been confirmed, either if they have been given to their step parents through a court order, through a high court order. So our focus will specifically be on children who are born by the parties themselves, whether they were born before or while the parties were married. Now, with regard to the children, the most important principle is the best interest of the children. And when we talk about the children, we're speaking about minor children, those who are before the age of 18 years, they can be 17 years, they're still a minor child, but as soon as they reach the age of 18 years, they reach the age of what we'll call they are now major children. Now we are going to the children must be just before the age of 18 years and going below. And the most important principle is the best interest of the child. So can one of you just explain to us when the court or when the law says anything with regard to minor children, you have to look at their best interest? What does that mean? You can give an example in answering. What do you understand when we talk about the best interest of the minor children? Anyone? Students? Just try using an example. You can even just do a scenario regarding what you understand by the best interest of a minor child.
Hello, ma'am.
Hi, Octavius.
Hi, morning. The way that I understood it, best interest of a child, let's say the child goes to a particular school, they've been there for quite some time, and now the parents are divorcing, and the other parent is maybe moving quite far away, and the kid has to change. So the best interest of the child is, of course, the well-being, education, and all of this is part of it. So just looking at overall what would be the best for the child and their well-being going forward.
Okay, thank you, Octavius. You are correct. Basically, it means in the context of divorce, when the spouses are undergoing a divorce, when it comes to the children, whatever decision they are going to take, it must serve the best interest of the children. Let's say, for example, let's say both the mother and the father, they want a primary residence of the child. We'll talk about primary residence. And now let's say the husband says, okay, because we both want primary residence of the children, let's have a joint primary residence, whereby this week the children will be staying with me, and then next week the children will be staying with you. Now the court will need to look at this arrangement where the children alternate. This week they are with the mother, the following week they are with the father. Does it serve the best interest of them? Because the parties, the spouses themselves, they can say, because we wanted the children, I wanted primary residence, you wanted primary residence, so we are gonna reach a compromise. So for them it may work, but the question is, will it work for the minor child? And for this, there are many things, there are many factors that we'll have to look at. Like, for example, you can say a minor child who's 17 years and a minor child who's 6 months. And let's say 6 months is still breastfeeding, or even 2 years, and is either maybe still very much attached to the mother or very much attached to the father. So it has to be looked as to whether will will the child alternating between the both parents, will it serve their interest? For the 17-year-old, for example, if the child alternates, when their schooling be affected, their extramural activities, and whatever activities that the child is involved in, won't that be interfered in any manner? And also psychologically, will the child be able to understand that this week they have to be here, next week they have to be there? Now, taking this to the child who's 5 years, for the child who's 5 years, again, if they go to crèche, will it work? Where are they attending crèche? The parents, the spouses, if they are now separated, and one lives, let's say, in Midrand, the other one lives in Soweto, will it work alternating the child? Because then it means the child's life must not in any way be affected by divorce. Yes, the divorce will affect the child because the parents are now separating, but their lives must, the interruption must be as minimum as they can, because at the end of the day, their best interest, their best welfare is the first thing that needs to be looked at before it can be determined if what the parties or what the parents are proposing can be made a court order. Secondly, can some of you, or one or two or three of you, tell us what are the factors that the court look at in determining the best interest of the child? The textbook lists various factors. In my example, I've just stated some, although I did not specifically say, like, for example, I gave an example of a 17-year-old. So one of the factors will be, they look at the age of the child, they look at the gender, they look at the school. There's a whole lot of factors which are stipulated in your textbook. So can you just discuss those? What are the factors that the court look at in terms of the Children's Act to determine whether whatever is proposed, it is in the best interest of the children, of the minor children? It is important that you remember that this is only applicable to minor children. Minor children remains the key word. Now, can somebody just tell us, 2, 3, or 4 of you, just tell us what are the factors that the court looked at?
Firstly, ma'am, they will be
Who's
looking
speaking?
at
Who's speaking? Who's speaking? Ntato. Okay, thank you.
They'll be looking at if the minor child has a disability or not. And another important point of consideration is if the child has any chronic illnesses, so that they can be taken care of going forward. And another, looking at the family the environment in the family. with looking at whether there is a volatile situation in terms of conflict in the household, and looking at the parent who, the attitudes of the parents regarding a parent who can best look after the kids, and also looking at the maturity of the minor children, even their stage, their development. At what stage are they in terms of development? Yes, those are the ones that I can list. I can leave the rest to other students.
Okay, thank you for that. Anybody else? Student, just take a guess. Okay, you're not supposed to take a guess. If you have a textbook near you, you can quickly check, because these factors are on page 172 and 173. Octavius, I see your hand, and Ethel, I also see your hand. And please, students, know that make sure that you know these factors, because they are very, very important, not just for the purpose of you passing the exams, but even when you, if you are going to be a practicing legal practitioner, and you get a client who has a matter regarding parental rights and responsibilities, you must know these factors. Okay, Ethel? Ethel? Ethel, unmute yourself.
Good morning.
Morning, Ethel.
Yes, some of the factors is the nature of the personal relationship between the child and the parent, and the capacity of the child to be able to take care of the child's needs, emotionally, including emotionally and intellectually. The practice, and the other one is the practical difficulty and expense of the child having contact with his or her parents, or a specific parents.
Okay. Thank you, Ethel, for that. Thank you, Ethel, for that. You are correct. The list is quite long, and it's not a closed list, because as the court looks at what is in the best interest of the minor children, even factors which are not here, the court will listen to any argument and consider any factors, as long as one has to argue that it is a factor which must be considered when it comes to the best interest of the children. As I have stated, students, please know, make sure that you know them. They're on page 172 to 173. Now we are going to move to the Mediation Incident Divorce Matters Act. But before I continue, I just want to know, is there someone, or has any one of you has ever had an experience with regards to a divorce which includes minor children? I'm now talking about the real life. Do you know what a family advocate is? Have you ever heard of a family advocate? So before you answer me the question about the family advocate, have you ever had an experience, or know somebody who has had an experience regarding a divorce which involves minor children, and you somehow have an idea as to what happens in real life with divorces regarding where minor children are involved? Anyone? Okay, let me ask this. Do you know what a family advocate is? Have you heard about the family advocate? Alfred? Alfred, unmute yourself.
Okay. Oh, yes,
Yes.
ma'am. Are you?
Yes,
Yes.
Alfred.
According to my understanding, the mediation is a person between the two people who are divorcing, whereby is going to to take or to consider the children's best interest if the divorce is finalized, and where the kid will be living, and will the kid be happy there. I think it's the person that is considering those factors.
Okay, thank you, Alfred. Nomsa? Nomsa?
Oh, hello, ma'am.
Yes, Nomsa?
I think a family advocate is it's an advocate who deals specifically with family related issues. Issues like wills, divorce. I think that's a family advocate.
Okay, for your comment, thank you. Lesedi? Lesedi?
Hello, can you hear me?
Yes, we can hear you, Lesedi. Yes.
Yes, according to my understanding, I think a family advocate is a person who puts down the information in front of the court just to balance out the recommendations and how must the matter be dealt with. Like they put on the facts of like the case, let's say between the two parties who are divorcing in this case, they lay out the factors that need to be brought forth, and then so that the court may be able to weigh it out.
Okay, thank you for that. Erisa Martin? Erisa, please unmute yourself. Okay, you can talk. Erisa, we are waiting for you. Erisa, we can't hear you. Erisa, we can't hear you. Erisa, we can't hear you. Okay, I'm going to continue because Erisa has unmuted herself, but for some reason we cannot hear. Okay, students, family advocate, it's a part of Department of Justice. So what's happening is when spouses are undergoing a divorce and there are minor children involved, the family advocate or the family advocate's office is mandated to make sure that the best interests of the children have been taken care of. So when spouses undergo a divorce, there are forms that they need to complete. The first form is called Annexure A. In the Annexure A, please, when you get time, Google family advocate Annexure A. Family advocate Annexure A, so that you get to see what I am talking about. That form, basically, the spouses have to write all the information about the minor child, and they also have to state there what is it that the parties have agreed upon. The role of the family advocate is only to deal with issues regarding parental rights and responsibilities of the minor children and nothing else. The family advocate, although they do mediation regarding parents who cannot enter into an agreement regarding the parental rights and responsibilities of their children, they are different from other mediators in that other mediators, they can deal holistically with the issues of the divorce, while the family advocate can only deal with the issues of parental rights and responsibilities only. Also, a student, when you get time, please, you can go to the website of Department of Justice, or you can also Google what a family advocate is, because it is very, very important that you know what is a family advocate, what role the family advocate plays, and what role the family advocate is not allowed to play. With regard to the minor children, the family advocate does not have any powers to deal with maintenance matters. They can only deal with parental rights and responsibilities, and that is regarding access rights, which now they are now called contact rights. So with regard to the terms, please, you must no longer use the words access and custody. We now use the word contact, we use the word parental rights and responsibilities, and we use the wording contact. Is contact right? Primary residence. Primary residency refers to the parent who will be staying with the children during the week, while the other parent will have contact rights, and they usually see the children every alternative weekend, and during school holidays and other holidays, the parents usually they alternate. So in terms of the act, the parent who does not have primary residence, in other words, who does not stay with the children on a daily basis, will get to see the children every alternative weekend. Although that parent who has contact rights must see the children every alternative weekend, there is nothing stopping the parent from reaching an agreement whereby they will say the parents who only has contact rights must see the children, let's say, no, normally a month has 4 weekends, so they will say maybe you will see the children on 3 weekends in a month, or sometimes one day during the week. Whatever agreement that they're going to enter into, and the terms has to be in the settlement agreement, it must serve the best interest of the minor children. So if their spouses decides that we are going to, you as the contact parent, you're going to have the children 3 times or on 3 weekends, while the parents who have primary residence will get to see, will get to spend only 1 weekend with the children. The family advocate may query this, because by saying the one parent gets 3 weekends while the other one gets only 1 weekend, the children's the children's right to have time to bond and spend time with the other parent is limited by saying they can only get 1 weekend. And this is because during the week, most adults are working. So even though you are staying with a child in your house, it does not necessarily mean that you get enough time to bond with the child. So whatever arrangement that they are going to reach, it has to serve the interest of the child and not the interest of the parent. And secondly, you need to understand and be aware that although one parent can have primary residence and the other one will have contact rights, both spouses will have what we call parental rights. Parental rights basically means that the major responsibilities and rights with regard to the minor children, they need to be jointly agreed upon by both parties. It does not, for example, a spouse or a mother or a father or a parent who has primary residence does not necessarily have more rights with regard to the children versus the other parent. So a good example I can talk about is schooling. You may be a mother who has primary residence of the children, and the father has contact rights. But when it comes to schooling, you and the father you need to decide, the two of you, which schooling are the children going to attend. It is not just the right of the one parent to make that decision. You also need to understand. That in terms of the Children's Act, the Children's Act and the Constitution, mothers are no longer given preference with regard to them having primary residence. there is nothing stopping the father from being awarded primary residency if it is in the best interest of the minor children, and for the mother to be given contact rights. And this applies even to small children. Okay, Erisa, let's hear what Erisa wants to say. Erisa, please, you have unmuted yourself, but you can't hear you. Erisa, okay, Erisa is not. Ntando, Ntato.
Hello, ma'am. It's Ntato.
Yes.
I want to find out, with regards to the family advocate, can the family advocate encroach on the jurisdiction of the court when the court has made a decision with regards after, let's say, subsequent the divorce, and let's say the parental rights are given to, let's say, the father? Can the family advocate encroach and make a review, or say, or perhaps say that the decision was not reasonable and just?
Yeah, no, the family advocate does not have the powers to do that. The family's advocate is to lodge an inquiry and prepare a report, which is going to be submitted at court. So what happens is, let's say the divorce has been granted and the father has been granted primary residence while the mother has been granted contact rights. And now the mother wants this to change. So the mother can approach the court. Let's say the divorce was granted at the regional court, formerly at the magistrate court. So the mother can approach the children's court to request that she be given primary residence of the children. And in her request, she's going to state her reasons. The family advocate will be appointed to lodge an inquiry regarding what is the best interest of the children, regarding whether the children must be moved from the father and be given to the mother. So for the mother to succeed, she must prove that circumstances have changed that are no longer in the best interest of the children that they live with their father. So when they lodge an inquiry, firstly, you need to know that attorneys are not allowed at the family's advocate's office. Third parties are not allowed. That is your parents, your spouses, or your family members. They are not allowed. They can come there to support you, but during the inquiry, they need to be out of the office. As in not where the inquiry will be. At the family advocate, it's going to be the family advocate, it's going to be the family counselor, it's going to be the parents, and it's going to be the children, if the children are of the age that they can also be interviewed by the family counselors. The family advocate will ask questions, to the mother, will ask questions to the father, and after that they will prepare a report, and this report will be submitted to court. The court then will have a look at the report of the family advocate, and it will decide if it's going to take it and abide by it and implement it in its court order, or is going to reject it. That is just the role of the family advocate. I will loosely use the word investigate, but they don't investigate. They lodge an inquiry, and then the parties will have either to go to them, but during COVID, they have been having telephonic interviews with the parents. Also, what the family advocate can do is, if, let's say, for example, one parent is claiming that, or is alleging that the other is abusing alcohol or is into drugs, they can give an order that a blood test be taken in order to determine if the allegations that are being made are actually true. So that also the family advocate can be summoned, can be summoned to court to come in either as a, not necessarily as a witness, but to come and explain why in their report they reached such a recommendation which they have actually reached. So those are the powers of the family advocate. But other than that, and even the report, let's say the parties themselves, they decide that, okay, let's just go to the family advocate and for the family advocate to assist us with the parenting plan. They have a right to reject that, and then at court they will just have to explain why they are rejecting the recommendations of the family advocate. But to answer your question, see, they don't have powers above the presiding officers. The presiding officers have the final say, but they do have the powers to lodge an inquiry regarding the best interest of the minor children, even when a court order has been given.
So, lastly, if I may ask, what about major children which are not capacitated to live independently, like such as okay, but they can make their own decision. However, the parents are disputing as to who should have parental rights or primary residence of the of such major children.
Okay.
So, yeah.
The family advocate only deals with minor children. Once you reach the age of 18 years, the family advocate no longer have any powers to deal with you. So if there is a dispute regarding a major child who is still in need of parental support, then the parents will have to hire their own private, there are private, what is it, the psychologists or private social workers who specialize with children's issues. But the family advocate has no powers to deal with anyone who has reached the age of 18 years.
Okay, thanks.
Okay, Lisedi?
Oh, hi, ma'am. I hope I'm not going out of the topic. I would like to ask if, let's say in an example of like two parents divorcing, and then there's like a 17-year-old who would like to be emancipated, and then during the interview with the family advocate, the child raises that they want to be emancipated. In that case, can the family advocate like lodge an inquiry based on that whole situation?
Okay, remember, if they want to be emancipated, they firstly need to bring a separate court application regarding that. They cannot make that part and parcel of the part and parcel of their parents' divorce. But the family advocate can, because they're 17 years and they're about to reach the age of 18 years. So where the family advocate can listen to them and give maybe a recommendation or a view in their favor is if they say, okay, I don't want to stay with both my parents, but I want to stay, let's say, with my grandmother or with the aunt or any other family members, and give reasons why they need to do that. So if they can convince the family advocate that I'm now about to reach the age of 18 years and it is not in my best interest that I live with both these two divorcing spouses, but I want to live in a place where it's going to serve my best interest, the family advocate can give that recommendation. Also, the court can also agree to that because there have been divorces where primary residence have been given to the grandparents or to other family members because of the situation of the divorcing spouses. Do you
Thank
understand?
you so much. Yes, thank you.
Okay. Does anybody have any question? Okay, the family advocate rights that in terms of the Mediation in Certain Divorce Matters Act. Please, the information regarding the family advocate is on page 174 to 175. Please make sure that you know it, especially what is the role of the family advocate and what is it that the family advocate can lodge an inquiry on. Because of the Constitution and because of the Children's Act, the family advocate now can lodge an inquiry on any matter that is related to the best interest of the minor child, as long as it does not it is not with regard to the maintenance matters, and it is now over and above what has been stated in your textbook, né? Because it's about care, it's about care, it's about primary, it's about contact, it's about primary residency, siblings which will be separated, because it happens not most of the time, but it has happened in some instances where the parents will decide that, okay, when you'll take one child and I will take the other child. So the family advocate needs to lodge an inquiry and see if it is in their best interest to separate the siblings. And in some instances, they have a rule that it is in the best interest of the children, especially when the children are a bit older, like from 16, 17 years, when they are very close to reaching the age of 18 years, and in circumstances require that maybe one lives with the mother and the other lives with the father. So it has happened that the family advocate does recommend that the siblings be separated, though this is something that is not encouraged and it is only granted in certain and in certain, like there must be exception, there must be really really good reasons why the siblings needs to be separated, and it must serve the welfare of the siblings and not of the parents. Okay. There's life. There's no name here, but it is listing here as life. Something something. Can you hear me? Live. Live. Zwakele. Zwakele.
Yes, good morning.
Morning, Zwakele.
Yes, for interest sake, because divorce has serious repercussions for children. So I'm asking, can children, especially those who are around 17 years, can children, through the family advocate, oppose the divorce of their parents, citing that not in their best interest? And they do that.
Okay, no, they can state that they are not happy with their divorce, but unfortunately, they don't have the powers to actually stop it. Yes, they will tell the family counselors that they are not happy that their parents are divorcing, and usually in that instances the parents will be encouraged to take their children to a professional, so that the professionals will help the children to deal with the realities of their parents' divorce. But other than that, the divorce will not be stopped because the children don't want their parents to divorce. We must remember that nobody can be forced to be in a marriage that they don't want to be in. So the family advocate and the court, they do not have the right to force spouses who the both of them have voluntarily agreed that they no longer want to be married to each other, no matter how painful it is for the children.
Okay.
Okay, thank you. Ntato, is your hand up or you forgot to lift to put it down?
Oh, it's up, ma'am. Can I just
Okay.
ask a question?
Yes, you can talk.
Okay, in a case whereby a married couple divorces and parental rights are given to perhaps the mother, and after
Yes.
after such time the mother passes on and she dies intestate, and the child, which is perhaps a minor at 12 years old, and now obviously the money is going to be taken, let's say, to the guardian fund.
To them directly, they have an account number.
Okay. Hello? I don't know.
Alternatively, she's placed into trust, we pay them from trust. Whichever way she can do it.
Okay, I don't know. Ntato, is that person talking to you?
I don't know what's happening.
Okay, and Ntato, let me just do this. Okay, I've just muted everybody. Ntato, please unmute yourself and continue.
Okay, thank you, ma'am.
Okay.
Like I was asking, if a child, a minor child, and a child in the parental care of a mother, and the mother passes on, so and the father has contact rights, so then the mother dies intestate, then the master, let's say now the money is taken to the guardian fund, then the father has the now is the only surviving parent, will look after and has to look after the child. So then I want to understand in terms of I don't know, intergovernmental relations between the guardian fund and the family advocate. Who supersedes the other? Who dictates to the other as to what should happen in relation now to the father now being the surviving parent, and the deceased wife, the deceased parent now having ascendance, let's say the mother. So who will take care of the child? Will it go to the ascendant, the parent of the mother who is passed on, who will take care of the child and take care of the child in terms of the guardian fund? Will it be the family advocate who will be dictating the order?
Okay, thank you for that question. And you're asking a very important question with regard to death. Yeah? Okay, so firstly, please, students, let us not make the mistake. Yeah? We have primary residency. That is related to who will be staying with the child. So you are the primary resident parent, and we have a contact parent. Then we have parental rights. Remember, parental rights are not just primary residence. So please, 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 we must always make sure that we don't make the mistake. Coming to Ntato. So if the mother has been given primary residence and she passes away, primary residence will go to the father because the father has parental rights. This applies not only to spouses who have been married, but also parents of unmarried children or adults who have children but they were unmarried. If you have joint and equal parental rights and responsibilities, when one parent dies, the other parent will now have primary residence of the child. So if, let's say, for example, the mother was staying at her home with the grandparents, grandparents don't have automatic rights towards their grandchildren. So if the grandmother will say, no, I still want my grandchild to stay with me, and the father is saying no, the grandmother must bring the matter to court for the court to determine whether it is in the best interest of the child to be removed from this primary residence to go and stay with the father, and the father is going to be given preference unless if the circumstances are such that the child must stay where at their grandmother's home. Yeah, and with regard to their inheritance, when parents die intestate, all the inheritance goes to the guardian's fund, and whoever is responsible for the minor children will go and claim the monies so that they've got enough for the survival of the child. They make a claim every year. So the money will be in the guardian's fund and it will be retained there up until the child reaches the age of 18 years. But the father, who's the ex-husband, because of parental rights. So we need to understand what parental rights involved. One of the things that involves is guardianship. It involves care. Please, this is in your textbook. So to understand parental rights, you must know, although it is important that you know the content, you need to read as much as you can of the in the textbook. You must know what guardianship entails, because guardianship involves the guardian being in charge of the child, minor child's financial affairs, minor child's properties. So let's say the mother passes away and she leaves an immovable property. Now the question is, who's gonna be in charge of that immovable property, since the child is still a minor child? So during the process of administration of deceased estate, the title deed of the immovable property can be changed into the minor child's name, and the guardian, who is the father, will be the one who is in charge of that. And the reason being is, in terms of parental rights, the Children's Act and the Constitution gives him those powers. So it is very important. Let's say now you have children, or also as a practicing legal practice, once you are a practicing a legal practitioner, it is very important to advise people, and also in your personal capacity, to have a will, because in a will you can state whom you want to be the guardian of your child's inheritance. For example, you can state that maybe the money can be deposited into or can be retained by the guardian's fund, or use other insurance policies which also offer the same, which also offer the same thing like the guardian's fund. But now when it comes to immovable properties, you must state that, okay, the immovable properties, the title deed must change into my child's name, and I appoint my sister or my mother or whoever to be in charge and to be in control of that property up until my child is at the age that they can be in control of. If this is not in the will, the law states the surviving parent is the one who has to be in charge of the minor child's affairs. So it was Ntatone who asked the question.
Yes, ma'am. Thanks.
Yeah, so do you understand now? Because the father will automatically get more rights by virtue of the fact that the Children's Act states that the surviving parent now will retain sole parental rights.
No, thank you. It's clear.
Okay, thank you. Precious? 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 Precious, please unmute yourself. Precious, please unmute yourself.
Okay, hello, ma'am.
Yes, you can talk, Precious. Yes, you can talk, Precious.
Okay, I like how you explained where a part where one parent died and the other is still alive and stuff. What about in a case where the the spouses were from different countries, like, yeah, and the other parent dies and the other one is left, and that child grows up to another country, raised by the grandparent, and the grandparents, they almost like refuse uh the child, the father, to see or to take, or for the child to visit him. Like, how do you deal with that? because father is like financially stable, you know. He does like the supporting of the child and everything, but the grandparents, they just don't want the child to visit the father on another country.
Okay. Firstly, with regard to if the father is no longer in South Africa, the father must bring a court application if the grandparents are refusing with the child. Remember, I said grandparents do not have any parental rights. So the grandparents cannot just refuse, because in the eyes of the law, the first don't have rights at all. So the matter must be brought to court to determine what is in the best interest of the child. The father will be given first preference unless if it can be proven that it is not in the best interest of the child, for the child to be removed from the grandparents and also to leave the country. It's
So
only
they need
that
to South Africa.
they need what?
So
The father is in South Africa.
Yes.
Okay, and the child is out of South Africa.
Yes.
Okay, the father will have to bring a court application where the child is. Unfortunately for the father, it is gonna be an expensive court application. Whereby, okay, this is the process if you bring a court application where the defendant or the respondent are not in the country. You have to appoint a South African attorney. The South African attorney needs to bring a high court application for permission to lodge an application to the other side. That's the first option. Or alternatively, and what is it? Alternatively, the father can find attorneys that site and correspond with them where the minor child is. Understand? And then that side, depending on their rules and on their policies. Remember, the law says you have to go where the minor child is. So if the minor child is in the UK, you have to go to the UK. The situation would have been different if the minor child is a South African citizen and let's say he moved or he went overseas. He went overseas temporarily with the mother, and the mother dies there. Then the father can can make the application in South Africa, because this is where the residence of the minor child is. So, in answering you, the key word first is gonna be what is the residence of the child, and yeah, what is the resident of the child. But if let's say there's a court order granting the father parental rights, let's say it's a divorce and the father was granted parental rights, then upon the death of the mother, there is nothing stopping the father from entering into a plane and going and fetching the child back, because remember, grandparents don't have rights. So a court order will protect the father, because it will state that me and the mother have have parental rights over this child, and because the mother has now passed away, then the father is the only one who will have parental rights. You understand? So is this a scenario, or is this a real life situation?
It's a real life situation.
Were they married or they were not married?
No, they were not married, just girlfriend and boyfriend, and then she suddenly passed on when the child was really young.
Okay, when last did the father see the child?
Every December he goes because of COVID. It's been 2 years now.
So
I
the
think,
child, has the child ever been to South Africa?
yeah.
Is it?
Yeah.
Okay. The
About
advice.
before, I'm not
Okay.
sure.
Okay. What I can advise, but here let's take the same scenario, but let's say the parties were married spouses and they've now divorced, and it was still a situation whereby, remember, if the child used to visit the father, it means that the father also had parental rights, which included having contact with the child. So what happens if what can happen is, which I think can be the best way forward, is to arrange contact with the child. In other words, you speak to the grandparents and you say to the grandparents, can I have the child over the December holidays? And once the child is brought to visit for the December holidays, then you bring a court application to have permanent primary residence of the child, since you are the only surviving parent.
And they do refuse those visits. They like, no, you just come and visit, see the child here.
Yeah. Okay. What is it? Okay, then the best thing is for what is it? For this gentleman to go and see attorneys who will actually help him to get his child back.
Thank you.
Okay, thank you for that. Okay, it's a real life, but it can be used as a scenario for spouses who have divorced. And then also, for example, let's say the mother has been given primary residency, and the mother, with an agreement with the father, lies to the father and then says to the father, okay, we are going overseas just for a holiday for 3 weeks, we are coming back, and the mother kidnaps the child does not come back. The father has right to bring a court application, but this time the court application is brought in South Africa. And in terms of the Hague Convention, in terms of the Hague Convention, the father can bring a high court application so that the child can be brought back to the country, even if, let's say, it happens that the mother dies at the site. And let's say the divorced spouse was not a South African, and after the divorce, she decides to kidnap the child and goes back to her home country. Then the father can bring a court application, a high court application in South Africa to have the child brought back, as long as the father has parental rights. Then the chances of them of succeeding will be very good, unless if it can be proven that it is not in the best interest of the child. It's not in the best interest of the child to be removed from that country. Okay, thank you so much. Students, does anybody have any questions? Students? Precious?
Yes, ma'am. Yes, ma'am.
Okay, I see your hand is up.
Oh, sorry.
Okay. Students, anybody has any question, anything to say? Students?
Hey, it's Nari here.
Nari.
Yes, I have a question.
Okay.
What is the court's view in terms of if the mother is acts of immorality? Is there still sort of a sort of frown upon that issue if the kids are in her custody? Yeah.
Okay, the first thing that needs to be determined is what do we mean by immorality? Because remember, morals are more of a subjective thing than objective. What you deem as immoral might not necessarily be immoral for me. Let me just give a good example. An example. Let's say okay, let me not use same sex, because same sex relationships are now legally recognized. Let me say the mother is a sex worker. Understand? Yes. But the mother is a very good mother, but for the fact that their profession is being a sex worker. Although the court will look at their profession, if it can be proven that, you know what, it is not in the best interest of the children to remove them from their mother by virtue of the fact that what is it? The mother is a sex worker. The children will not be removed. So the key words again is what is in the best interest of the children, irrespective of what you may deem as immoral.
All right.
Understand?
Okay.
So yeah, now that basically it. But the courts don't because they look at objective, they look at the facts. They will never take what you as the other parent they say it is immoral.
All right.
Understand?
Okay.
Okay. Ethel, I see your hand.
Hello. Hello. I
Yes,
want to
Ethel.
ask with regard to maintenance.
Yes.
At what does the law say about the age on how to maintain a major child, an adult child beyond school, like school years? Maybe the adult has finished schooling, he's not working, but it's not like he cannot get a job. He's not willing to get a job. What does the law say about that?
Okay, I'm going to mute. Everybody so that we can hear. Major children, once you reach the age of 18 years, I keep on repeating this. Once you reach the age of 18 years, you are now an adult. As an adult, if you want maintenance or if you want to be supported by your parents, you must bring a court application in your own right. So, in the example that you have just given us, the major child must bring a court application at the maintenance court, and the magistrate they will have to decide if they will grant this maintenance or not. The maintenance application must be brought for both parents. So you cannot, as an adult, only bring a maintenance claim against your father, but leave your mother. You understand? It must be brought into an end. But to answer your question, they need to bring their own maintenance claim. So if the child is still living with you as the mother, unfortunately, you cannot bring a maintenance case on their behalf. Okay, do you understand? Okay, Alfred, before Alfred, Don.
Hi, ma'am.
Yes, Don, I'm listening.
Yes, ma'am. Just for interest sake, ma'am, I just wanted to know whether these sessions are recorded. If so, is there a way that we can get access to them, maybe for revision's sake?
Yes, the recordings, you can locate them on the PVL2601 on the thing, on my modules under additional resources. So go to the my UNISA PVL site, and
yes,
under there, go under additional resources. Then you will see there's a tab which says what is it, the recordings. So all the links are there.
Okay, thank you so much, ma'am.
Okay, thank you. Okay, we're going to have the last ones. The last one is going to be Alfred and then Ntato. Alfred? Alfred?
Oh, sorry for Muti. Yes,
Okay.
can you hear me now?
Yes, I can hear you now.
Yes, I'm saying if it finds that the mother or the father is not a good parent and is being proven, but the child himself says that no, you know what, I want to stay with that parent. So now, and the child, the age of the child is like maybe it's underage, like maybe 5 or 7 years. How will this be dealt with? Will the child be taken because he's a minor? Then the mediator will will have a look or final say, or how do they deal with this?
Okay, for a very small child of that age, it is very unlikely that their views will really be taken into account. Instead, it will be suspected that that they have been coached. Because if a minor child or a very small child says my mother is not a good mother, they must give reasons. Now, let's say they say, okay, my mother is an alcoholic, he has beaten me, and all of those things. So they need to investigate whether those allegations are really true, or if the father has not coached the child to say those things. And it's important to note that at the family advocate office, the family counselors, they can actually pick up if the child has been coached. And also, again, the family counselors, they don't necessarily have to, they listen to the children, but because they also take into account their age. There has been many occasions where children under the age of 7 years, 8 years, they don't really interview them because they take the view, not all of them, not just some, they take the view that they are not really of that age, they are not matured to really understand, and even if they interview them, whatever they are going to say, those children cannot really be taken that serious or into account. The only difference will be maybe when we talk about abuse, excessive abuse, rape, and all of those things. But again, even those, there must be proof. It can't just be the child who says, I don't want. Let's say another example, let's say the parties are now divorced and the mother is given primary residence. The father comes, it's a Saturday, he now comes to pick up the children for his contact weekend. And the children simply say, no, we don't want to. Understand? So it needs to be investigated. Why are the children suddenly say they don't want to go with the father? Is the mother influencing them? So in those situations, if let's say the children say we don't want to go and the mother is supporting the children, the father, the ex-spouse, can bring a court application that his rights and the rights of the children are being infringed upon, and the court order is not being followed, because when it's his time to have contact with the children, he does not get access to the children because he does not get access to the children because the children are just saying no, they don't want to, but there is no reason why they don't want to, and the family advocate during the divorce process ruled or gave a recommendations that it is in the best interest of the children that they have contact with their father.
Okay, thank you.
Okay, thank you. The last one will be Ntato.
I would like to find out, in a case whereby, in relation to the question that I asked previously, in relation to people who are concubines, and now there's a case whereby the mother is passed on, and now the father automatically has a leverage in terms of being the guardian of the child or taking over the guardianship of the child. Then there are concubines, and the grandparents argue that no, according to customary laws, they cannot, in terms of object the concubine father taking having parental rights and permanent. What did you say? What did you call it?
Papa says, okay, firstly, for others to understand, when you're talking about concubine, you're actually talking about cohabitation, right? That is cohabitation when two unmarried parties live together. The law that governs the rights of children is the Children's Act. It is not customary law. So in terms of the law, when the mother passes away, the parent who will have a primary residence and sole parental rights will be the father, irregardless of whether that father was married or not married to the mother, and irregardless of the fact that the father did not pay customary damages. The Children's Act is clear by saying fathers, unmarried fathers who have automatic parental rights and responsibilities are married fathers, whether those fathers are in a civil marriage, same-sex marriage, or customary marriage, or religious marriage, and unmarried fathers who are in a cohabitation relationship. But there's also other rights which fathers get, like for example, a father who was paying maintenance but was not living with the mother also obtains automatic parental rights and responsibilities. So a father, whether a father who was in a civil marriage and divorces, if the grandparents take the child, all they need to do is just go to court and enforce their rights, or they can just make an arrangement with the parents, with the grandparents, that please, can I come and visit, or can the child come and visit me? And once the child is in their care, then they can bring a court application just to for the court to confirm their rights, and also to give an order, making sure that the grandparents are aware that the only thing they can have is contact rights, but they will not be given a primary residence, or they will not be given a parental rights. But remember, the key here is the best interest of the minor child. That is what determines everything at the end.
Okay, no, thanks.
That's it. Okay, students, thank you. Thank you for joining this session today. Can I ask that you be on the lookout for announcement, because there is a possibility that there's gonna be a session again sometime this week, but it's going to be on Facebook. They're still finalizing the logistics of that. So for now, I cannot say anything up until we receive the final confirmation. But please be on the lookout. Be on the lookout for announcement, or if you are on Facebook and you are on the UNISA page, I think the information will also be there, because the session will be discussing about the exams and all of that. So please be on the lookout. Yeah, for that. It's an announcement which can be made anytime from now. Okay, thank you. The last one will be Mapile.
Hello.
Yes, Mapile, you are the last one.
Yes, I just wanted to ask, what will be the format of examination? And it will, again, will this thing of indicator app allowed in this exam for family law?
Okay, your examination will be MCQ, ne? So it will be a random of questions. So it will, I won't answer by saying focus specifically mostly on this, and then no, this one just exclude, because it's not going to be there. It's going to be just a random of questions. So my advice to you is read as much as you can and expect any question. Expect any question.
Okay, thank you, ma'am.
Okay, thank you.
Okay,
Thank you.
regarding to investigator app,
Okay, I can hear you now.
regarding to investigator app, are we gonna use the investigator app in our session?
Okay, for that again, please wait for the announcement. Unfortunately, I don't deal with the exam side, so that is why some of the questions I really cannot answer. Thank you for that. Thank you, students. We shall meet again next week, and those who will be fortunate to join the Facebook session, we shall see each other on Facebook. Thank you, and have a good day ahead. Thank you, students.
Thank you, ma'am.
Bye.
Thank you.
Thank you,
Thank you.
ma'am.
Bye.
Thank you. Thank you.